Hello, everyone. This is Joe Tomeno. I'm a healthcare principal here at Grassi Company. Grassi is a full-service accounting and consulting firm in New York City, Westchester, Long Island, and New Jersey. And we're pleased to present today, along with our colleagues at One Group, a webinar on New York State paid family medical leave benefits law. My colleague Jerry Greger and I were sitting down a few weeks ago, and Jerry works extensively not only in healthcare but also in the construction industry and not-for-profit and higher education groups. And we were saying how all our clients are asking us about this new New York State paid family medical leave law. So we thought it would be helpful to put together a webinar for our clients, and we tapped into our good friends at One Group to join us on that, and we're here to present today. So with me today is Audrey Villani, and Audrey leads our human resource consulting practice here at Grassi, and she'll be presenting on behalf of Grassi. And I'll turn it over now to Joey to introduce her group from One Group.
Great, thanks, Joe. And we obviously want to thank Grassi for inviting us here today. So One Group, briefly, we are a full-service insurance agency doing all lines of commercial insurance. We also partake in consulting and risk management. And we're here today, and I have on the line both Grassi Co and Kathleen Russell, who will be presenting with Audrey. They, on behalf of our company, have followed this legislation quite closely. It did not go away. In fact, it's here. And we need to gear up for it. It is a complicated subject, so I think today will be more of a treetop overview, but I'm certain that there'll be more questions. A little about Grassi and Kathleen. They have over a decade of experience, and they, together with Audrey, I'm sure, are going to be able to at least start the process in preparing you and your companies on what needs to be done. So without further ado, I think that we should start.
Very good.
Okay.
Great. Good morning, everyone. Thanks, Joey, for that introduction. This is Grassi Co
and Kathleen Russell.
And we thank you all for taking the time to hear about paid family leave. And it is certainly a hot topic, and one I'm sure that you've all heard of, in different phases. Kathleen and I joke that our children are very well versed in PFL as we read up on it constantly and share what we learn with our children. So they are also very well versed. But we will spend, as Joy mentioned, a little bit of time. It is more of a treetop overview. There's a lot to paid family leave, as I'm sure you are all aware, and so we will dive right in. This presentation is not meant to convey legal guidance. Again, it will be provided, or we will provide an overview of paid family leave. And certainly, as this is a new law, we anticipate additional interpretive guidance once the law becomes effective and is officially rolled out.
All right, just a quick look at our agenda for today. We're going to cover a timeline of events from the inception of this law to today. We're going to do a benefit overview, cover what the employee rights and obligations are with paid family leave. We'll discuss the similarities and differences between paid family leave and family medical leave, as well as the New York State disability law. We'll get into a discussion about next steps for employers, and then have a period at the end for questions.
Okay, so timeline of events. How did we get here? As Joey said, it is here. It's one of those things where I think we're all on the fence on it, or about it for some time. But if you all can remember, way back when in April of 2016, paid family leave was signed into law by Governor Cuomo. Then we had almost a year, go by, and we received proposed regulations on, how we will roll out paid family leave. And what we later learned is that it's actually the first draft of the proposed regulations. About 3 months later, in May of 2017, we received the second draft of the revised proposed regulations. Shortly thereafter, the Department of Financial Services released their regulations on the topic. And then June 1st, is when we learned about what the maximum employee contribution would be, and also learned that that would be the maximum premium rate. So the employee contribution rate equals the premium rate, and that was released in June. In July is when we were aware that employers could begin the payroll deductions. And then moving along, in late July, we received the final regulations. So the long-awaited final regulations were released in July 19th. August 1st is the last day for disability carriers to decide whether to remain in the market and provide disability, which in turn means that they have to provide the paid family leave. September 30th, which is around the corner, is the last day for employers elect to self-insure the benefit. And then November 30th is the last day for those that are not required to offer the benefit to let their employees know and the workers' comp board know if they are going to offer the benefit or not. And then, of course, drum roll, January 1st is when paid family leave goes into effect.
We'll get started on the benefit overview. Paid family leave amends New York's workers' compensation law, and in particular, the disability benefits law. It will cover all private sector employers with one or more employees who are subject to the New York disability benefits law. So what that means is, as an employer, if your employees are on your statutory disability or DBL policy, then they will be required to be on the paid family leave or PFL policy as well. And if you have questions as an employer as to whether this is applicable to your employees, certainly your broker or insurance carrier for your DBL can provide more guidance since it is a rider to the DBL policy. If you're a public employer, you're not required to offer PFL to your employees, but you may opt into the benefit through voluntary coverage. And employers that self-insure their DBL rather than have an insurance carrier handle that for them will have the option to elect to be self-insured for the PFL benefit or obtain alternative coverage for PFL through a carrier. This election, as Casey mentioned in the timeline, to self-insure must occur no later than September 30th. And we would caution that what we're finding is a lot of the DBL carriers are not offering standalone PFL policies. So if you are an employer who self-insures your DBL currently and you're thinking about fully insuring the PFL, you'll really want to make sure to get on that as far as checking with carriers to see if you can find one who will offer that standalone PFL policy. Unionized employers, if they have leave provisions in their collective bargaining agreements that are at least as favorable as the PFL leave benefits, they will not have to offer PFL. So for unionized employers, they're really going to want to take a look at that language to make sure it matches up with the PFL law language, and then consider what potential bargaining obligations they have that might need to be undertaken before this takes effect in January. And then, important to note, an employer must use the same carrier for paid family leave as they use for their New York State disability policy. So that will appear as a rider on the statutory disability policy.
So a little bit more about what is PFL. As we know, it will become effective January 1. And what the program provides is it allows employees in New York State job-protected paid leave to either bond with the employee's newborn child or a newly placed adoptive or foster child during the first 12 months following the birth or the placement of the child. It also allows employees to care for a close family member with a serious health condition. And we just want to point out the definition of a family member. In paid family leave and PFL, a family member is defined for this provision as a spouse, domestic partner, child, parent, parent-in-law, grandparent, or grandchild. So that is quite an expansive definition of family member, more so than what we're used to with, for example, family medical leave. So it is, a pretty broad definition of a family member. Paid family leave also allows employees to assist with family obligations due to deployment or impending call or order to active military service. And a relative in that provision is defined as spouse, domestic partner, child, or parent. So it's important to, understand the definitions of a family member and how it applies and the different provisions of paid family leave.
All right, so this slide is of particular interest. It shows how this benefit is going to be phased in over the course of the next 4 years. And it's important to note that this schedule is somewhat tentative because the Superintendent of Financial Services will have discretion to delay any of these increases in the benefit level if it's deemed that such increase will have a negative impact on the state's economy. But as it's laid out right now and anticipated, as of January 1st, the maximum amount of paid leave available to eligible employees will be 8 weeks in 2018, and that will be paid at a rate of 50% of the employee's average weekly wage up to a maximum of New York State's average weekly wage. And New York State's average weekly wage is currently $1,305.92. So if you look in the last column, in 2018, the maximum weekly benefit that an employee could receive is $652. And then when you carry that through for the other years, you can see in 2019, the maximum weeks of paid leave goes up to 10. The maximum percentage of the employee's average weekly wage increases to 55%. And then in the last column, therefore, with the 55% versus 50% in 2018, the maximum weekly benefit goes up to $718. That, of course, is using the current state average weekly wage, which is subject to increase. So the $718 in 2019, and then the subsequent $783 per week, $874 per week, those could all be larger numbers once we get there. But this just demonstrates, so you can see at a glance, what that potential weekly benefit could equate to for an employee. And then as you see, we talked about the maximum weeks of leave increases in 2018 from 8 to 10 weeks, and then caps in 2021 at 12 weeks maximum for the employees to take leave, and the maximum benefit caps at 67% in 2021. It's important to note, too, that that maximum leave amount, that number of weeks, may be taken in any given 52 consecutive week period, which starts with the first day the employee takes leave. So that's how that calculation works. And then just also of note, as we said, that New York State average weekly wage is subject to change each year. And typically it's March 31st that the DOL would update that number. Even though it would update potentially in March of 2018, that increase for purposes of paid family leave would not be noted until January of 2019. So this $1305.92 is the set amount that will be used for calculations in 2018. And then that $1305.92 equates to approximately $67,908 on an annual basis. So you can gauge for employees that make greater than $67,908 per year, that last column, the maximum weekly amount that they could get for the benefit, those employees making greater than $67,908, that would be the applicable amount for them. If your employees are making less than that figure, they're going to cap at 50% of whatever their actual average weekly wage is.
So funding. Kathleen and I received a lot of questions on how this benefit will be funded, exactly how it's going to work, and how the payroll deductions work and things like that. So the benefit will be employee funded through a payroll deduction, and the amount was released by the Department of Financial Services, and it's 0.126% of an employee's weekly wages. And again, it's capped at that 0.126% of the New York State average weekly wage, which is what Kathleen was speaking to in the last slide. So the most that can be deducted out of an employee's paycheck for 2018 is $1.65 per week. And what the Department of Financial Services released is that the premium is a community-rated premium, and that's how it will be billed within the employer's disability policy. And the premium is the same calculation as the employee's payroll deduction. So the premium is the 0.126% of an employee's weekly wage, capped at 0.126% of the New York State average weekly wage. So again, the premium is a community-rated premium. So no matter what carrier in New York State offers paid family leave, the premium rate is the premium rate. It's this 0.126%. And this premium and the employee deduction will be established each year on September 1st. So potentially, although this is what is established for 2018, this could potentially change come 2019 and so on and so forth. So again, that will be released, that rate will be released each year by September 1st by the Department of Financial Services. Employers have the option to cover the cost and pay the PFL premium directly if they choose to do so. We've received questions on that, on, as an employer, can I cover the cost of this benefit? Certainly, we haven't come across anything that indicates otherwise. However, the intent of the law is that it will be employee funded through that payroll deduction. However, certainly employers can choose to cover the cost and pay the premium if they would like to do so. Also, Kathleen and I have had several questions on whether or not to, when, I guess, to begin the deductions. It was written in the regulations that employers can begin the deductions July 1st of 2017, even though the benefit will not become effective until January 1, 2018. The reason behind that is, different employers have different policies and different billing cycles. So, for example, some employers may have their disability policy due January 1 to cover the entire year. So in that instance, an employer may want to consider starting those payroll deductions early to be able to build a pool of funds to pay that PFL premium that may become due January 1 for the entire 2018 year. However, other employers may be billed quarterly in arrears, meaning that they might receive a bill at the end of the first quarter 2018 going back to January 1. In that case, an employer may not have to begin the deduction until January 1 in order to be able to pay that premium.
All right, moving on to employee eligibility. To be eligible for PFL, employees who work 20 or more hours per week must be employed with that current employer for 26 consecutive weeks to be eligible for PFL. And employees who work less than 20 hours per week in order to be eligible will have to have worked 175 days in a consecutive 52-week period. So when we talk about employees who work 20 or more hours per week, that will be all of your full-time employees and some of your part-time employees. When we talk about employees who work less than 20 hours per week, that would be the remainder of the part-time employees. And when we talk about the employees who are working less than 20 hours per week, the 175 days is actually 175 days worked, not calendar days. So there will be some tracking necessitated by this. If you don't currently have an HRIS system that can incorporate that tracking, employers will need to figure out how they're going to calculate and track each day worked for those part-time employees who are working less than 20 hours per week. The employer must provide any employees who are anticipated to work less than the 26 weeks or the 175 days with the option to file a waiver of benefits. If it's anticipated upon hire that an employee is never, they're working 20 or more hours per week, but they're never going to be with the company for 26 weeks, or if they're working less than 20 hours per week and they're not anticipated to work 175 days within 52 weeks, such as maybe a well, obviously part-time, a seasonal employee, or someone who, maybe is a student who works just for summers. Those employees have to be provided by the employer with a waiver, so that waiver would exempt the employee from having to make the payroll contribution, and therefore it would exempt the employer from having to provide that employee with the PFL benefit. The waiver is going to be in a format prescribed by the Workers' Comp Board Chair, but they have not yet released that form for us. So we need to stay tuned for some information that we're still waiting for from the Workers' Comp Board. Additionally, if a waiver is on file for an employee who is not expected to meet the eligibility criteria, that waiver will be revoked within 8 weeks if there's a change in that employee's schedule, and it is then anticipated that the employee will actually continue to work up to or beyond 26 weeks or 175 days within a consecutive 52-week period. At that point, if the waiver is revoked, the employee then has an obligation to begin making contributions through payroll deduction, including any retroactive amounts that may be due from the employee's date of hire when it was initially anticipated they would not meet eligibility. This is one of really the only instances where a retroactive amount can be recuperated from an employee. For instance, we've had some questions as to, okay, we've passed July 1st and realized, oh, we really should have started taking this deduction from our employees beginning in July, and we didn't. Can we go back and retroactively take that amount that we would have taken had we done it timely? The answer to that is no. You can begin taking them now, but you can't go back retroactively if you, missed your mark and didn't start July 1st and wanted to. Just as when we come up to January 1st, if an employer, forgets for some reason and come March, they say, oh, geez, I was supposed to be taking this deduction from my employees as of January 1st. It's too late for the employer to go back and recoup that. They can go forward starting with the payroll deduction, but they can't retroactively collect back to January 1st. It's also important to note that as far as eligibility determinations, ultimately it's going to be the DBL, PFL carrier who makes any determinations on employee eligibility. And very important to note that paid family leave is not available for an employee's own serious health condition. So that would be a major difference for those employers who are covered by FMLA, where with PFL, employees are not able to take leave for their own serious health condition.
So diving in a little bit further about when and how you can take the leave as an employee, we talked a little bit about the main provisions. However, you can take leave for the birth, adoption, or foster care. Leave for birth is available during the first 52 weeks after the date of the birth of the child. So that is similar to FMLA, but an employee does have the first 52 weeks to take leave to use their, 8 to 12 weeks, depending on when, what year they're looking to take leave, but due to the birth of the child. Leave for foster care or adoption is also available during the first 52 weeks through either the date of the placement of the child or the first day leave is taken. So this is a little bit different from the birth of a child because in some instances an employee may have to take leave before the child is actually placed with them due to requirements such as court appearances, doctor visits, traveling to another country. Instances like that, they are able to begin the leave starting then, and then they would have 52 weeks starting from the date that they take the first day of the leave to take the remainder of their leave. And an eligible employee may elect to receive disability and paid family leave after the birth of the child, but they may not receive the benefits at the same time. So that's important to know. Really, a maternity leave type of situation is really the only situation that, that we're aware of where someone may be eligible, an employee may be eligible for both disability and paid family leave. So disability due to their own serious health condition, and then paid family leave due to the birth of a child or for baby bonding. In that instance, again, they can receive both benefits, but not at the same time. So an employee may say, I would like to use my 6 or 8 or however many weeks for disability, and then their paid family leave benefit could begin after that. So again, they can be stacked in that situation, but they can't overlap. It is important to note that an employee may not exceed 26 weeks of either disability and paid family leave within a 52-week period. So combining those leaves, someone cannot take more than 26 weeks, again, in a 52-week period. Now, it's also important to note that this paid family leave, it does go into effect January 1, as we're all aware, but it may apply to children who were born or placed for adoption or foster care in 2017. So you may have requests beginning as early as December 1st, if an employee gives 30 days notice, for leave beginning in January, if a baby was born or placed in 2017, because an employee does have, again, 52 weeks to use that leave. So this does apply to babies that were born or placed in 2017. So stay tuned. You may certainly be receiving requests for that as early as December 1st.
All right, another form of leave is to provide care to family members with a serious health condition. Providing care includes such things as necessary physical care, visitation, transportation, arranging for changes in care, assistance with essential daily living matters, things of that nature. The employee in this instance must be in close and continuing proximity to the care recipient. So the questions we've received here have been, well, what if I live in New York State, but my mother who needs care lives in Florida? Can I take paid family leave to care for her? The answer would be yes. However, you have to be in close and continuing proximity. So the expectation would be that for the duration of the paid family leave, you would be in the same general location as the care recipient. So in this scenario, it would be anticipated that the New York employee would physically be in Florida to be able to care for her mother who resides there. And important to note, which we've already touched on, but for those of you who are also covered by FMLA, that the definition of a family member in this scenario is defined as a spouse, domestic partner, child, parent, parent-in-law, grandparent, and grandchild. So again, a much more expansive definition compared to FMLA, whereas FMLA only includes the spouse, child, or parent.
Speaking a little bit further about the serious health condition, a serious health condition is defined as an illness, injury, impairment, or physical or mental condition that involves inpatient care or continuing treatment by a healthcare provider. So the treatment does not include routine exams. So therefore, typically, unless certain complications arise, conditions such as the common cold, upset stomach, routine dental work, are examples of conditions that would not meet the definition of a serious health condition under PFL. So, therefore, if a child, for example, is homesick from school due to having the cold, a common cold, that instance would not qualify under paid family leave. So it is a serious health condition, and it's defined very specifically in the regulation. So routine, appointments or exams, common cold, stomach aches, things like that would not qualify as a serious health condition, unless, of course, there's complications that may result in a serious health condition. But in and of itself, those conditions do not meet the definition, so PFL would not apply in those situations.
All right, and then the final form of leave is leave for a qualifying military exigency. This would be leave to assist with family obligations that result from a family member's impending call to active duty or current active duty in the armed forces of the United States. So essentially, this follows the Family Medical Leave Act guidelines, where reasons for such leave might include having to make child care arrangements, rest and recuperation of the service member, if there's deployment with short notice of 7 days or less, certain military events and activities that require attendance. So very similar as far as the guidelines that we are currently familiar with for family medical leave. The family member for this scenario is defined differently, and we have touched on this. It's defined as a spouse, domestic partner, child, or parent. And again, for family medical leave, it would only be spouse, child, or parent. So for military exigency leave with paid family leave, domestic partner becomes a qualified family member. And that's really the only difference between paid family leave and family medical leave as far as the qualifying military exigency leave is concerned.
Thanks so much. Good morning, everybody. My name is Audrey Villani. I'm from Grassi Consulting Division. Today I'm going to discuss the New York Paid Family Leave Employee Rights and Obligations. I will also discuss the similarities and differences between a few other benefits that are constant questions to the clients that we have. There's a lot of confusion between paid family leave and paid family leave and family medical leave. There's a lot of similarities, but there are a lot of differences, and I'll go through that during my time today. So to start off, employees will be responsible for notifying their employer of their intent to use family leave benefits and for filing those leave requests, including supporting documentation. So employees will need to provide that 30-day notice unless there's any unforeseen issue. A family member, becomes has a serious medical condition, it was unforeseen, we would waive the 30-day notice period at that point. Employees must request their own paid family leave, so it's not up to the employer to offer it, the employee needs to request it. And they need to file for their own request. So the employee will directly speak with New York State with their claims. New York State did not release any of the forms as of yet. I expect them towards the end of the year. And supporting documentation must be provided from the employee. And some of those pieces of documentation, for some examples, would be for a birth of a child, a birth certificate, adoption or foster paperwork is another. Certification from a healthcare provider, it would mirror the same certification as FMLA does, and federal military leave forms for any military leave purposes. So regulations now require employers to have paid family leave posted. I'm sure it will be a part of one of those labor law posters that you'll see in January that we will need to post in employee areas such as break rooms and such. Make sure you update your handbook with the rights, duties, the law, and how to file for claims for your employees. That is now a requirement. Employees, again, must file directly with the insurance carrier. So employees will fill out the paperwork and communicate directly with the carrier regarding their claim. And payments or denials of their claim will be processed within about 18 days. The payments will come via check, debit card, or direct deposit. The employee will have that option. Employees who take family medical leave will not be discriminated or retaliated against by their employer, such as FMLA has the same standards. So if employees are going on paid family leave and it's a bad time for the business, there's no retaliation. The employee can't be written up or anything along those lines. Some similarities to FMLA is insurance must be provided and the job must be restored at the end of the leave. So for employees going on leave, you have to make sure whatever contribution you have being taken out of the employee's pay continues while they're on that leave. So before employees go on a leave, it would be a good practice to have a checklist of paid family leave as well as FMLA, so you can have that interactive conversation with the employee regarding their benefits, when payments are due, and who they need to contact. This is a new law that will be effective January 1st, so I assume there's going to be a lot of questions regarding it, and it's just good to have that interactive conversation with your employees to let them know what exactly they're eligible for and what they would be receiving as well. Employees cannot be required to use accrued paid time off benefits such as vacation, sick, any paid time off while they're on leave. It could be an option. Employees can use that option during their leave, but you cannot force them as you can with family medical leave. A lot of family medical leave policies, you must exhaust your time while you take leave, but paid family leave is much different. So some similarities between paid family leave and FMLA. One similarity is that 30-day notice that the employer needs to provide to the employer. Another one is the employee doesn't specifically have to state the type of leave requested, and the employees always have to provide that certification for their leave of absence. The paid family leave doesn't give anybody a gateway, to not provide any documentation and just willy-nilly go on a leave of absence. There are no waiting periods, such as FMLA, and again, the job has to be restored and the job will be protected while on leave. Group health coverage continuation must be offered to the employee, and this is not to be confused with COBRA benefits. The employee contribution must remain the same for the entire span of leave. So employers that feel that someone should go on COBRA, that's not the case. No accruals of seniority while on leave. That's also similar to FMLA. You keep your seniority, but it doesn't grow while they're on leave. In addition, there's no accrual of benefits on leave, so there's no accruing PTO or sick benefits or anything along those lines during that absence. And as stated before from Casey and Kathy, the definition of a serious health condition is the same. So FMLA and paid family leave are definitely confused because they have quite a few similarities. So moving on to the differences between paid family leave and FMLA. Paid family leave is a state program that is paid. Again, it's a state program. Every state has different laws regarding it. Rhode Island, California, New Jersey, and New York are the states that offer the paid family leave, and FMLA is a federal program that is unpaid. So all the states do have to follow FMLA and offer it to their eligible employees, but it is unpaid. So that's a big difference there. And both programs could be used together as well. Paid family leave cannot be used for employees' serious health condition, whereas in FMLA, you can. Paid family leave also does not cover prenatal conditions. A lot of questions came about with prenatal conditions for the paid family leave, because the first thing people think of is maternity benefits with paid family leave. And unfortunately, that is not the case here. So any prenatal conditions would not be covered under paid family leave. Paid family leave must be offered to private employers with one or more employees, whereas family medical leave, they have a minimum of 50 employees in a 75-mile radius for eligibility for that benefit. Paid family leave is optional for public employers, and FMLA includes public employers of any size. So there's a big difference there as well. Paid family leave has shorter requirements in order to be eligible, and is available to part-time employees as well. Whereas family medical leave has stricter eligibility requirements of 12 months of service and 1,250 hours worked in that year. So big difference there for eligibility. Paid family leave uses a 12-month rolling method to calculate time, and FMLA gives the employee the option, or gives the employer the option of a rolling method or a calendar method. And just to note with that is, it would be a good practice to have the calculation methods mirror paid family leave and FMLA leave, being that they could be taken together. It would be very tough to calculate paid family leave and FMLA leave for one employee when they're using two different measurement periods. So that's just something, you know, you should think about when you're updating your policies and your handbook come January 1st, when you do have to add this paid family leave law and the procedures in there. You may want to take a look at your your Family Medical Leave Act policy and procedure, because you may want to change the calculation method because it would be very difficult administratively. Continuing on with differences between paid family leave and FMLA is paid family leave must be taken in full day increments, where FMLA does not. FMLA provides employees more accommodations, such as reduced schedules, and they could take quarter-hour increments. With FMLA, you can force the employee to exhaust all of their paid time off, and with paid family leave, you can't, but you must give them the option. Make sure all of your policies state that the employee has that option. Paid family leave does not have a limit on how to define a child. Yes, they do not have a limit yet. FMLA classifies a child to be under the age of 18 years old for that eligibility classification. Family member classifications are also different, as noted earlier in the presentation. Paid family leave includes grandparents, grandchildren, domestic partners, and parent-in-laws. Family medical leave does not recognize these categories as covered family members. After the paid family leave is fully phased in, employees can take up to 12 weeks of leave, and family medical leave provides up to 12 weeks leave as of now, and provides even more time for military caregivers. So if employees are using both benefits, they would be paid up to 12 weeks when it's fully phased in for a military leave, and would take the remaining unpaid. Intermittent leave is also allowable for both paid family leave and FMLA, but FMLA allows the intermittent status as long as it's medically necessary, where paid family leave does not. Here I'll discuss some similarities between paid family leave and New York State disability benefits law. And again, another confusing topic. So both paid family leave and New York disability are state programs. They are both paid benefits, but private, and they're both offered to private employees with one or more employees, and they must participate. They also do not allow accruals of seniority and benefits while on that leave. And they are also both required to have that certification of the need in order to take the absence. So there are quite a few similarities, but there's even more differences. So for paid family leave, employees pay 100% of their paid family leave premiums. New York State disability is primarily employer funded. Payroll deductions will differ from each benefit. Paid family leave payroll deductions is 0.126% of an employee's weekly wage. And as stated earlier in the presentation, the current weekly wage, which will change in 2019, is $1,305.92. Employees' payroll deductions for disability are much lower, maxing them out to 60 cents per week. Speaking of payroll, paid family leave employee deductions are post-tax deductions. Earlier in the year, when paid family leave came about, they did not have an answer. So it is and has been confirmed that they're post-tax deductions. New York State disability is also used is used for employees' own non-occupational illness or injury, with a benefit of 50% of the employee's weekly wage and capped out to $170 per week. Whereas employee paid family leave benefits cannot be used at all for employees' own illness. So continuing on with some differences between paid family leave and New York State disability benefits law, paid family leave does not have a waiting period, and New York State disability has that 7-day waiting period. The eligibility periods are also different. Paid family leave requires an employee to be employed for 26 weeks and part-timers for 170 days for their current employer, whereas New York State disability's requirements are much less, with 4 consecutive weeks and 25 days work for part-time employees for any covered employer. There's a big difference there as well. The length of benefits are longer with New York State disability, offering up to 26 weeks and paid family leave providing 12 weeks when they're fully phased in. Paid family leave provides income replacement and job protection, whereas New York State disability does not protect your job. It only assists with your income replacement. The option for the job protection while using disability would be FMLA. So right now I'm going to turn the presentation back over to Casey and Kathy to discuss the next steps for employers with this law.
Thanks so much, Audrey. We appreciate that overview, and you're exactly right. There's certainly similarities between PFL and FMLA and also New York State disability, but there's a lot of differences as well. So I think it's so important for employers to be aware. There's certainly similarities with some of the laws and what we're used to and eligibility and how it works and things like that, but there's so many more differences as well. So it's just important to try to stay on top of these requirements and make sure open communication with employees so that they can understand what their benefits are as well. I think that communication is so important. So now what? So where are we? Next steps for employers. Now that we have, the overview of paid family leave, and we're, gearing up for this 1/1 effective date that will be here before you know it. And here we are, almost the end of August. What can we do? So, consider the impact on your existing practices, policies, and postings. So as Audrey mentioned, consider changing some of your existing leave practices and policies that to more closely match PFL or to align with PFL. So as Audrey mentioned with FMLA, FMLA gives employers the choice to choose how to define your 12-month year. Is it a rolling year, forward, backwards? Is it a calendar year? So, consider changing that and lining it up with PFL so that you have the same method for calculating somebody's eligibility. It's important to note that if you are going to change your method for calculating leave time with FMLA, FMLA does require 60-day notice to employees to make that change. So, keep that in the back of your mind, review policies, and if it makes sense to update your policy, your FMLA policy, then employees need 60 days notice before that change goes into effect. Also, as Audrey mentioned, there will be the requirement of the PFL policy. So that will need to be something that's implemented, and the guidances or the regulations, are clear on what needs to go in that policy. So there'll have to be guidance on how the PFL benefits will be administered to employees. It should include employees' rights and obligations, and then also instructions on how to file a claim. So as Audrey mentioned, the employees will go to the insurance carrier or directly to the carrier to file the claim. However, the employer has to have the policy that outlines exactly what they need to do. And employers should be aware too, very similar to FMLA, and as Audrey mentioned, once the employer becomes aware that there could be a PFL scenario, the employer, needs to give the employee the required information of what they need to do in order to file their claim. So an employee doesn't actually have to say, I need or would like PFL, but once the employer has enough information to know, geez, they're looking for leave to take care of a family member or to bond with their baby or, something like that, that is enough information for the employer to know to point the employee in the right direction. So just things to be aware of. Also, consider staffing options, such as either cross-training employees or bringing on temporary individuals on board. And that's to fill potential gaps that may arise due to the level of leave or to the amount of leave that your employees may take. And evaluate whether outsourcing absent management is a viable solution. Again, you could receive requests as early as December 1st for January 1. So this is coming and it'll be here again before we know it. So there's a lot to track and a lot to administer with PFL. So it may be helpful to see if there's a potential absent management solution that will track PFL, FMLA, should that apply to your organization, so that that administrative piece, would be carved out to a vendor.
In regard to absence management solutions, it would be a good idea to reach out to your DBL carrier, or if you have a broker or consultant that handles your DBL, regarding what options are out there for absence management services. because there's a huge administrative burden, as I think you're probably all appreciating at this point in the presentation, with tracking and managing all of these absences, particularly in the scenario where there are intermittent leaves. Also compliance, there's complex state and then federal laws that are at play here at the same time. So compliance is a huge issue where an absence management service could help you as an employer stay in compliance with these laws. And as Casey just mentioned, coordinating across these various leave types, particularly when there is concurrent use. You've got the federal family medical leave, state leave laws such as this, PFL, military leaves. You might have employer-specific leaves that all interplay. Important to note as well, if you are an employer covered by the Family Medical Leave Act and you have an employee with an eligible leave request for paid family leave, the employee filling out the request for paid family leave does not relieve you of the responsibility to provide them with the family medical leave paperwork as well. So you want to make sure, and again, another reason why absence management tracking services could be so helpful, you want to make sure not to miss the mark on that. So PFL and FML can run concurrently, but the employer has an obligation to make sure to provide the paperwork for family medical leave as well as the paid family leave paperwork. And then obviously all of this absence management assistance would minimize the business risk and potential liability to the employer. We have done a little bit of research with some of the carriers, and they may have options available. Typically right now we're seeing the options are for groups that have 50 plus lives, and that is because until now family medical leave was the big one that would trigger an employer to want this type of a service, and only employers with 50 or more employees would have family medical leave. So we're hoping to see more carriers providing options for less than 50 lives, since paid family leave is for one or more employees. But we've seen for PFL tracking in the neighborhood of 15 cents per employee per month, and then for FML tracking anywhere from $1.60 to $2.31 per employee per month. But this would be another area where it's just really a good idea to reach out to either your carrier or the broker or consultant that you use for your GBL, who will also be handling your PFL, and see what options and pricing are out there with the various carriers.
So to sum up again with next steps for employers, there seems to be quite a few slides on next steps, but again, consider consulting with your disability carrier or your consultant regarding your current policy, and again, potential absent management services in the event that that is an option that makes sense for your organization. Also, consult with your payroll vendor regarding setting up the new payroll deduction code. Kathleen and I have come across some organizations who the payroll provider has decided to implement the deduction July 1. Make sure you're in communication with your payroll vendor so that you're on the same page as far as when you're going to start that deduction, and also so that you can communicate that deduction to your employees. Also, speak with your internal accounting department to review any process changes. You're going to be deducting that the payroll deduction from the employees. It has to be pooled in a fund so that you can use those funds specifically for paid family leave. So talk with your internal accounting department on how to designate those funds. And again, communicate the payroll deduction to the employees prior to implementation. There's not an actual it's not included in the regulation that this is required. However, it's certainly recommended and best practice to make sure that your employees are aware of the payroll deduction. So advance notice is certainly recommended in that instance. And then, as we mentioned before, develop any internal policy changes, establish what those are going to be, and then communicate those to employees as appropriate. And then once released, post the PFL notice in plain view of employees and applicants. So again, As Kathleen mentioned, we're waiting on the waiver from the Workers' Comp Board along with the PFL notice that will be required to be posted. So once that is released, that is something that employers should post.
Great, thanks so much, Casey. So at this time, we're going to take a few questions. We have a few minutes. So a couple of questions that came in. One of them is, if I live in Connecticut and work in New York, can I claim the paid family leave benefit? You are eligible for the benefit if you travel to New York State for work for at least 30 days in the calendar year. So you can definitely claim that benefit if you are working in New York State for 30 days in the calendar year. The next question is, if my employer already offers a paid family leave benefit, can I still apply for the paid family leave benefit with New York State? Well, that depends. If your employer covers over and beyond of what New York State family paid leave provides, then you're not eligible for the benefit. If not, you can definitely claim that benefit. The next question is, can my spouse and I take paid family leave at the same time? Yes, you can, as long as you have different employers. Multiple family members can also use that benefit as well. If you have the same employer, you would have to take turns taking that benefit. You can't be using the benefit at the same time. Next question we have here is, can I use paid family leave for a family member who lives outside New York State? I think we had something about this in the presentation. Yes, you can. You can use the paid family leave regardless of the location of the family member that you're caring for, as long as you're in close and continuous proximity of that family member. So if they're in Florida, they expect that you're in Florida taking care of that sick family member in that state. The next one, I'm getting a few questions regarding when should I start the payroll deduction. Well, it's kind of a personal choice. By law, you could start the deductions July 1st. Realistically, it depends on what works for you. Employees are not eligible for the benefit until January 2018, so it's up to you how much you wanted to deduct in advance. Some clients prefer to deduct fourth quarter to pay for the first quarter premiums, and some rather front-load the premium knowing it's a mandatory deduction and they'll recoup the cost. So some are even starting January 1st. It's a personal choice. It's what works for you. Also think of how the employees would view that as well. So if you're deducting July 1st for a benefit they're not eligible for in January, you may get some disgruntled employees and some pushback. But again, it's really what works for you financially and what you would like to do with your own company, but you're by law allowed to make those deductions as of July 1st. So other questions are coming in regarding unions and what unions should do. So I'm going to turn that question over to Joey for more clarification.
Sure, thank you. And again, Kathleen and Casey, thank you so much with Audrey. This is a lot of material to digest in a short period of time, and I have no doubt, if you want to go to the next slide, that when those questions come up, Audrey is right here to assist you. Unions are very interesting, and we probably have a lot of different spaces here. I particularly have clients in the healthcare space together with Joe Tomeno, but that is not by far the only union. But I can share with you that I've had a handful of clients now receive formal letters of notice from 1199 stating that they will not, and they put the employer notice, do not start taking deductions before January 1st, 2018, because the position taken is that this is a bargain for term change in condition of employment. So if you are unionized and you haven't received such notice, I suspect that you will be receiving this shortly. I think other unions will follow suit. This is an SEIU. And keep a heads up, and we'll have to see where that goes with other union dialogue.
Okay, great. Thanks so much, Joey. So we've had an overwhelming response to questions. Unfortunately, we ran out of time, but for further questions, feel free to reach out to me. I'll be happy to discuss any HR topic with you. Grassi offers a full-service HR consulting division that can assist you with any paid family leave changes or any other HR topic that you need assistance with. I'd like to thank One Group team and the Grassi team for the webinar, and to all of you for your attendance. Have a great day.
And I'm just going to say one other thing I forgot to say, so I apologize. One group is working on a toolkit that we'll be working on with Grassi to be able to help their clients. Thank you.
Great.
Thank you.
Thank you.
Have a great day, everyone.